All right, so let's talk about our top takeaways from the program. One of them is that even though we're talking about new technologies and things that haven't been raised in court, at some point they will be. And even if you don't ever defend a murder case involving a Fitbit, you can still look to the Carpenter-Augustine analysis and all the issues that we've been talking about for the last 3 hours and see how courts might rule and what you should argue as far as a reasonable expectation of privacy, whether your client has voluntarily exposed or shared information according to the third-party doctrine and other legal principles that the courts have addressed. It's going to apply basically across the board anytime we're talking about information that a person seeks to keep private. All of these issues involve interesting challenges with respect to, as I mentioned before, what are we actually waiving? Do we know that data is being collected on a daily basis with or without our consent? And do we voluntarily give up that data simply because we check a box on a user agreement that nobody bothers to read, or because we haven't flipped to page 80 of the manual that came with our TV, and so forth? Other takeaways?
Yeah, there's, as I think my handout illustrates, there's a lot of devices that are out there, and they're all generating a lot of data. And the reliability of that data can vary a lot, device to device and circumstance to circumstance. And to pick up on something I think we mentioned earlier, is it's important when you think about getting this into evidence is to just make sure you're closing that loop, right? Is the Fitbit saying 0 because the person is dead or asleep, or is the Fitbit saying 0 because the Fitbit fell off? You know, there's various things that could be accounting for the data that you're seeing. These devices, because they're targeted to consumers, sort of come pre-baked with a lot of inferences. You know, a step is a step and not just a clap. I think my highest step day ever when I was wearing a Fitbit was one of the ALDS Red Sox games when I was clapping an awful lot. It was one of the good ones. And so my steps were through the roof because I was clapping so much, and yet each clap was being measured as at least one step. So, you know, just remember that when these things are presented to consumers, they're making a lot of those inferences already for you. And if you're doing a good job, especially on the defense side, you want to unpack and interrogate and critically examine the inferences that are baked into these models.
Yeah, the flood of data is growing ever larger all the time, and so you really need to be sort of forward-thinking and aggressive to stay on top of it, both in what you can try to force the prosecution to tell you and in working with your own experts. You know, you can't just give a discovery dump of digital stuff to a digital forensics person and expect that person to process it in a way that is really useful to you. You need to be much more participatory yourself in terms of thinking collaboratively with that person about, okay, what are they trying to show and what else can we find to help build the context around that? You know, the forensic person that you hire doesn't know anything about your case, and so it's really incumbent on all of us and our staffs to sort of become more conversant with that with the technology and what it can and can't show ourselves, so that we can, you know, minimize the damage that it causes on the one hand to our cases and maximize the advantage that we can distill from it.